Let's dive right into the incredibly high-stakes world of child welfare law. It's a place where two massive principles are constantly in conflict: the state's undeniable duty to keep children safe and a parent's fundamental constitutional right to raise their own family. It really is a battlefield of good intentions, where the futures of kids and parents are hanging in the balance. Just listen to that. That's a staggering claim, pulled directly from a federal civil rights complaint. It's alleging that the state didn't just step in, it effectively erased a mother from her daughter's life and did it all without a proper trial. This isn't just some dry legal argument. This is the heart of a real mother's fight against the entire system. All right, so how are we going to unpack all of this? Well, first, we'll dive into the specific case that's at the center of this storm. Then we're going to zoom out and get a handle on the system itself, the players, the rules. We'll break down the major legal fights here over free speech, disability rights, and due process. And finally, we'll tackle the biggest question of all: can this system even be fixed? At the very heart of all this are two people: Kelly O'Neill and her daughter, Mara. Their family story, which is unfolding right now in North Carolina's court system, really shines a light on some of the most critical and, frankly, most controversial issues in child welfare law today. And look, this isn't abstract. This is a real, actual court summary from their case. It all started in late 2023 when the local Department of Social Services, or DSS, filed a petition. The state believed it had a reason to get involved, claiming the child was both neglected and dependent. That one document, that one piece of paper, set off a chain reaction that would put a family's most basic rights on trial. So, to really get what's happening here, we need to understand the machinery of the child welfare system itself. Who are the key players on the field, and what do all these legal terms actually mean? Let's break it down. In pretty much any child welfare case, you've got four main actors in the room. There's the DSS social worker, who is managing everything on the ground. You have the guardian ad litem, or GAL, who is appointed by the court to be the voice for the child. Then there's the DSS attorney, who argues the state's case. And finally, the judge, who has the ultimate power to decide everything. It's a really complex web of people, all supposedly working for the child's best interests. Okay, now this is critical. This is the legal basis for the state to get involved in the first place. A child can be called neglected if they're not getting proper care. Makes sense? But they can also be labeled dependent just because a parent isn't available and there's no one else to step in. These two definitions, they are the legal gateways for the state to walk right into a family's life. And this brings us to the first huge legal battle in the O'Neill case. And it's a big one. It's about one of the most fundamental rights we have: freedom of speech. The question is pretty stark. Can a court just order a parent to be silent? Just read this. This is the exact wording from the court order given to Kelly O'Neill. It is a sweeping gag order. It's not a suggestion, it's a command. She is completely banned from talking about her own case on any social media. The scope is just massive. Which leads to the obvious question, right? How is that even possible? The First Amendment is supposed to be a cornerstone of our legal system. So what on earth could justify this kind of extreme restriction on someone's right to speak? Well, the legal bar is supposed to be extraordinarily high. It's a test called strict scrutiny. Basically, for a court to limit speech, it has to prove two things. First, that there's a compelling interest, like protecting a child, and second, that a total gag order is the least restrictive way to do it. Honestly, these orders are considered unconstitutional right out of the gate. So here you have the two sides of the coin. The court justified the order, saying the mother's posts were inflammatory and threatening, but her lawyers are firing back, saying it's a blatant violation of her rights. They argue there's no nexus, no real link between a Facebook post and the original reason her child was taken away. But this case isn't just about free speech. It gets even more complex because it pulls back the curtain on another huge issue: the rights of parents with disabilities inside the child welfare system. And then came this moment, which was an absolute game changer. The court made it a formal legal finding that Kelly O'Neill was incompetent. This wasn't just an opinion. It was an official determination based on her mental health diagnoses. That one word, incompetent, changed everything. Now, this is exactly where federal law is supposed to step in. You've got the Americans with Disabilities Act, the ADA, and Section 504. These laws are designed to stop this kind of discrimination. They require public agencies like DSS and the courts to make reasonable modifications for parents with disabilities.
The system is supposed to adapt to them, not the other way around.
And you should know this area of law is changing as we speak. Just this past July in 2025, a new federal rule kicked in to make these protections even stronger. It spells it out in black and white. You cannot terminate parental rights based on stereotypes about a disability.
And this is the fundamental tension. The state's main job is protecting the child. So when a parent doesn't follow the plan, they see it as a choice, a refusal to cooperate. But from a disability rights point of view, that same behavior might just be a symptom of a disability the system failed to accommodate. So the question becomes, is the parent failing the system, or is the system failing the parent?
Okay, this brings us to the most severe, most constitutionally troubling part of this case. The accusation here is that the mother's rights weren't just limited, they were effectively terminated without the legal process that the Constitution absolutely demands. Take a second and just let this sink in. The language is absolute. Any and all visitation or contact shall cease. And the scariest part, until further orders of the court. There's no end date, no path to get contact back. It's a full stop.
There's a legal term for this. It's called a de facto termination of parental rights. De facto is just a fancy way of saying in effect. The argument is that this no-contact order does the exact same thing as a formal termination. It ends the relationship, but it does it by going through a legal backdoor, skipping the high-stakes trial that's supposed to happen.
And this is why it's such a huge legal problem. See, for a simple no-contact order, a judge just has to decide it's in the best interests of the child. But to formally, permanently terminate parental rights, the state has to prove parental unfitness with clear, cogent, and convincing evidence, a way, way higher bar to clear. Using the easy, low standard to get the most severe outcome possible is a major constitutional challenge. Now, the problems we're seeing in the O'Neal case aren't happening in a bubble. They point to much bigger concerns that have actually sparked some major reform efforts in North Carolina. So the big question is the system trying to fix itself? And you can see there's a lot going on. There's the Fostering Care Act, which just kicked in, giving the state more oversight. We've already talked about those new federal disability rules. There are also pilot programs, like the Safe Babies Court, being tested out. It's pretty clear this is a system in flux, and it's trying to respond to exactly these kinds of challenges.
So in the end, we're left right back where we started with this huge, fundamental question. This case and the entire system it represents really forces us to confront a difficult truth. When the state steps in with the absolute best of intentions to protect a child, how do we make sure that a parent's most basic rights, the right to speak, the right to parent, the right to just exist in their child's life, don't get accidentally erased in the process? Finding that balance, that's the tightrope this system has to walk every single day.